Welcome back to True Crime Stories. Court is now in session. This is your week 2 courtroom recap. We're going to go over all the testimony, evidence, all the drama. Every trial tells a story, and this one has been nothing but drama from the start. So, if you're ready, let's get into it. Day 6 of testimony brought the jury deeper into both the medical findings and the digital evidence surrounding Kouri Richins' death. The state first called Dr. Kouri Richins, the chief medical examiner for the state of Utah and an expert in forensics pathology. He explained to the jury how medical examiners determine the cause of death and the manner of death. The cause of death refers to the medical reason someone died, while the manner of death is classified into categories such as natural, accidental, suicide, homicide, and undetermined. In cases involving drug toxicity, he explained determining the exact circumstances of how a substance entered the body can be difficult. Drugs may be ingested, injected, inhaled, or taken in other forms, and toxicology results alone cannot always establish the precise sequence of events. He also testified that fentanyl is an extreme potent opioid. It's estimated to be roughly 80 to 100 times more stronger than just morphine, and that many fatal overdoses occur when the drug suppresses the breathing. Toxicology testing in Kouri Richins' case revealed the presence of fentanyl in his system, along with quetiapine, I cannot say that word, a medication sometimes prescribed for psychotic conditions. The medical examiner also told the jury that fentanyl was found in the gastric contents, suggesting that the drug was likely ingested orally rather than introduced through injection. Autopsy photos showed no documented injection sites, which investigators typically look for in evaluating how a drug may have been administered. He also testified that acetylfentanyl was detected, and that's a compound often associated with illicit manufactured fentanyl rather than pharmaceutical sources. He also emphasized on the important limitation in forensic toxicology. Even when drugs are detected in the body, toxicology results alone cannot always determine which substance was taken first or an exact sequence of ingestion. During cross-examination, the defense attorneys questioned whether additional testing could have been performed. Dr. Christensen acknowledged that in some cases, tests such as hair follicle analysis may provide information about long-term drug exposure. However, he explained that such testing is usually only conducted when specifically requested, and noted that he was not aware of a standard hair follicle test specifically used for fentanyl in this case. The court also heard testimony about communication between the medical examiner's office and outside individuals. Dr. Christensen acknowledged that while it was uncommon, the office did receive a call from Kouri Richins. On January 12th of 2023, that date is wrong. No, it's not. It's right. On January 12th of 2023, after another doctor had referred the matter, a recording and transcript of that call were introduced into evidence. Dr. Christensen told the jury that at that time, based on the information available to him, he did not have concerns about the medical determination or the cause of death. He reiterated that while toxicology findings can identify substances present in the body, they do not always provide a full picture of the circumstances surrounding the death. Next, the state played the video of Robert Crozier's police interview. Now, I don't have the video to play for you here, but I encourage you to go find it and watch it, because he claimed that he was out of it, he was confused, and he doesn't remember anything he said. In my opinion, the only thing he was confused about was details regarding himself. He was pretty clear about everything else, so I encourage you to go watch that and form your own opinion. Next to testify was Molly Crosswhite, and she testified about purchasing a home from Kouri Richins in January of 2022. She told the court that she did not know Richins personally and that the transaction had been handled through real estate agents rather than direct communication between the two of them. She explained that the purchase agreement for the property was entered on January 14th of 2022, and they officially closed on the property on January 26th of 2022. During her final walkthrough of the home before closing, she said that the house appeared empty and that the furniture had already been removed. After purchasing the home, she intended to rent it out to tenants. According to her testimony, the property remained unoccupied for some time before the tenants eventually moved in on March 30th of 2022. Crosswhite also testified that the locks on the property had not been changed after the purchase, meaning the same locks remained on the doors from the time when the house was owned by Kouri Richins. She further explained that when she obtained the key to the property after closing, it had been left hidden on the front porch for pickup. During cross-examination, defense attorneys asked whether she recalled seeing boxes containing cups in a closet during the walkthrough. Crosswhite testified that she did not recall seeing any boxes like that. Now, this house that she's talking about is the same house that Carmen Lauber testified to going to leave drugs in the fire pit, drugs in a box in a closet, and she also went to this house one time to get money for a drug purchase. So, you got to remember that little detail. This is the same house. Next to testify was Allison Wright, who is Kouri Wright's wife, Eric's business partner. She told the jury that she had known Eric since junior high school, and that she later became acquainted with Kouri Richins through Eric, and that the families had remained socially connected for years. They had maintained contact with the Richins family, Kouri's family, extended family, over time, and they were close. During her testimony, she described a 2019 vacation to Costa Rica. She took that vacation with Kouri Richins and Eric and Cody. So she told the jury that during that trip, the two women spent time alone, and Kouri opened up to her about the difficulties in her marriage. According to Wright, Kouri said that she felt trapped in the relationship because of a prenuptial agreement and expressed frustration that if the marriage ended, Eric would remain financially stable while she would not. Wright also described Kouri as very ambitious and said that some of the tension Kouri discussed involved her business goals and the pressures surrounding them. During cross-examination, the defense questioned Wright about whether Eric had been involved in a relationship with another woman. Wright testified that she was aware that Eric had a friendship with another woman, but had no knowledge of an affair. She also testified that she did not remember having conversations with Kouri about that topic at the time on vacation. Wright told the jury that after Eric Richins' death, her family has remained close with Eric's family. Detective Jeff O'Driscoll, a major crimes investigator, was called to the stand for the sole purpose of being able to admit a phone into evidence. He was asked about how the phone came into evidence, if he and Miss Chelsea Gibson had performed an extraction on the phone, and he testified that yes, he had. When the defense cross-examined him, all they asked him was the lead investigator on this case, and he replied yes, he was, and he was released off the stand. Outside the presence of the jury, the court addressed a matter after receiving a note regarding a potential issue with one of the jurors. Defense attorneys raised concern that a juror may have had prior business transaction with either Molly Crosswhite or Allison Wright. I'm not 100% clear on that. Because of this possible connection, the defense asked the court to question the juror further. During this discussion, the defense also raised a separate concern related to the language used in courts when referencing recorded phone calls. According to the defense, the term jail calls had been used by Chelsea Gibson instead of a more neutral phrase home wave calls. Defense counsel Kathy Nesser argued that the wording could be prejudicial because it might lead jurors to believe that Kouri Richins had been incarcerated, which could influence their perception of the case. Citing case law regarding potential juror prejudice, the defense moved for a mistrial, arguing that the reference could improperly suggest to the jury that the defendant had been jailed. Attorney Kathy Nesser argued the motion on behalf of the defense, stating that the situation was not the fault of the defense, but that the potential prejudice warranted a mistrial. After hearing the arguments, the judge denied the motion for a mistrial. The court explained that given the nature of the charges in this case, it would be likely and very reasonable for the jurors to assume that the defendant had been incarcerated at some point, and therefore the reference did not rise to the level of prejudice required to grant a mistrial. Chris Kotradimus, a digital forensic investigator with M20 Solutions and a former law enforcement investigator who worked on homicide cases, testified next. He explained that the digital forensics is the analysis of electronic devices, including cell phones. In this case, investigators reviewed hundreds of phones connected to this investigation. I don't think it's hundreds, but it was a lot. He described the use of CellWrap, a forensic tool that extracts the data from phones and allows investigators to analyze the results. The reports generated from these extractions can include calls, text messages, web history, and the movement of the device. He also explained that call detailed records, or CDRs, which comes directly from the phone carrier records themselves. These records show information such as date and time of phone calls or text messages, the phone numbers involved, call duration, and cell tower locations, but they do not contain the content of the text messages. He said that these are considered business records and they're maintained by the carrier, typically for at least a year. When analyzing phones, investigators compare the data extracted from the phone device or device in general with the carrier's CDR records. He went on to testify that if something is deleted from a phone, it may still be recoverable. Deleted items can sometimes be restored, though they may appear marked in the system to indicate that they were previously deleted. He reviewed several phones in this case, including phones connected to Eric Richins, Kouri Richins, Carmen Lauber, Robert Kozier, and Josh Grossman. According to his analysis, there were no evidence of mass deletion of data on some of the phones examined, but some of them did have mass deletion. He testified that Kouri Richins used 3 phones during the time frame of the investigation. One of them was a white iPhone that she used from September of 2020 through April of 2022. A silver iPhone used from April of 2022 through May 2023 when she was arrested. And there was also a blue iPhone used beginning April of 2022. I don't think that date's right. I think I wrote that down wrong. Because she had 2 up until the time they took her phone. And then she only had 1 phone up until the time that she was arrested. So The blue phone and the white phone were both used from September of 2020 to April of 2022 when they took her phone. And then she got a silver phone that she used from April of 2022 through May of 2023 when she was arrested. I wrote that down wrong. He also explained that some communications occurred through VoIP applications, which use the internet instead of cellular networks. And because of that, those communications would not appear in the carrier call detail records. Investigators looked for communications related to THC gummies and located 3 conversations, including one in November of 2021 and one in January of 2022. They also analyzed communications between Kouri Richins and Carmen Lauber from January of 2022 through March 15th of 2023. 2. There were about 800 text messages, averaging that's like 10 to 11 a day. After March 16th, communications dropped significantly to only about 650 messages over the next 9 months, averaging about 3 per day, representing a 70% decrease. Records also showed that on February 11th of 2022, calls were placed from Kouri Richins' phone to numbers associated with the IRS. The forensic review also examined phone activity around March 3rd of 2022, the night Eric Richins died. Records show a phone call around 8:30 p.m., lasting only about 8 minutes, followed by a Google search at 9:45, and additional device activity recorded by the phone's sensor late that night. No worries, we're going to look at some evidence. Let me get those popped up on the screen for you. Okay, so what we're looking at here is information from Kouri's phone. Okay, so you can see that at 3:06 a.m., the phone unlocks for 28 seconds. And then at 3:07, there's a speaker activation. And then at 3:08, it recorded 243 feet worth of movement. At 3:10, her phone unlocks for 1 minute and 40 seconds. 3:15, it unlocks for 37 seconds. 3:19, it unlocks for 28 seconds. And just like literally a few seconds later, it unlocks again for 3 seconds. At 3:21 a.m., the device travels 135 feet and 911 is called. And the little blue receiver activation at the bottom, he testified that that's when the phone is actually put up to your ear. So, complete speculation, but I feel like maybe she might have had it on speaker and then picked it up. I'm not sure. But I've also got the phone activity, so we're going to look at that. Okay, so this is her phone activity. I should have done these backwards, like this one first. But this is her phone activity from 8:30 p.m. to 12 a.m. So you can see that the device travels so many feet. I can't see it on my screen. It unlocks at 8:35 and then locks back, and then it unlocks again at 8:46 and then locks back. 8:48 we're unlocking, locking back. 8:55 we're unlocking, locking back. 9:30 we're unlocking and locking back. The device after 9:30, the device remained locked until 3:06 when she unlocked it again. But it did record some movement. 35 feet. So I'm curious to know what they think that is. Okay, so this is Eric Richins' phone activity from 8:30 p.m. to 12 a.m. Okay, so he got the phone call. I have a hard time seeing it on my screen, but I'm going to leave it up so y'all can look at it. But he got the phone call. It lasted about 8 minutes. It shows his Google search, and then it shows when his phone locks and there's no remaining activity. So I'm just going to leave this one up there for a few seconds so y'all can see that, because the next thing we get into is a little juicy. Screenshot this stuff if you want to. That way you can blow it up later and see it. Okay, we're going to move on to the next stuff. Okay, I'm showing these a little bit out of order. I know, but this one is the cell tower mapping for Carmen Lauber and Robert Crozier on March 9th. Okay, this is when she says that there was a third time she bought from Robert Crozier, and he said no, she didn't, that there was never a third time. This cell phone mapping proves that they went to the Maverick. It was the same pattern of text messages to him and her, text messages between her and Kouri, the same meetup, the same pattern on March the 9th for the third buy that she testified to. Okay, so keep that in your head. That's why I put this one first, because she said there was a third and he said there wasn't. And this cell phone tower mapping shows that they met a third time. And it is exactly like the other two. We're fixing to look at the other two. Okay, so this is from the same day, the March 9th. And this is showing the text communications between Kouri and Carmen all throughout the time before Carmen went to the Maverick and then on her way back. So that's just establishing the same pattern on March 9th that we're going to look out for the other two buys that were already confirmed by Robert. So here we go. This one is the February 11th buy. This is the one that happened before Valentine's Day. And this is the only one that Robert Crozier fully admits to remembering. Even though he does admit to remembering a second, he's like, it could have happened. It could have happened. And I know that a lot of people speculated on whether Carmen Lauber was telling the truth, but I found her very, very credible. That's my opinion. But this shows the mapping from them two on February 11th, and that is before the attempted murder charge with the Valentine's Day sandwich. Okay. This one is for the February 26th buy when Kouri Richins had asked for something stronger. This is the buy right before Eric Richins' death. And you can see they're pinging at the Maverick, both of them. I didn't include Kouri's text messages through this because we've seen the first one how it was on the March 9th call. On the March 9th buy, it's the same thing for February 11th and February 26th. But to me, this was very, very vital information. And guys, if you go watch the trial, they flip through the slides and it actually moves. So you can literally see them going and then coming. And then as the text messages come through, you'll be able to see the timestamps a lot clearer. But it was hard for me to include all that over here and not be like 4 hours long. Okay, this is showing Eric Richins' February 14th physical activity from his phone. He had an 87-minute gap in the middle of a workday. And they testified that when they compared this to his other activity for previous days, there was no gap. So this is when he ate the sandwich, got sick, had a bad reaction, is what they're calling it, had to give himself an EpiPen, and then they're saying, well, he got up and went to work later, so it was not as dramatic as he made it out to be. This was an 87-minute gap in a workday from a man who never had a gap like this. To me, this was big. Next, they went over the Google searches, and we've already been over those, guys. So if you haven't watched my previous video, go back and look at it because I included as many as I could on that video of the deep dive, going down the rabbit hole. When they presented them in court, they only presented obviously the stuff that was relevant to the case. So obviously when she searched what kind of doctor was Dr. Pepper, that wasn't relevant. Then we saw some text messages between Eric and Kouri on Valentine's Day. So the green is Eric, and it says, "Kay, I'm going to go lay down for a bit. If I don't start getting better, I'm going to head to the hospital." And this was at like 11:30. And then she sends back like 15 minutes later, "Geez, It's that bad? Question mark. Need me to come home? Go take a nap and call me when you're up. Now, you have to remember, she was with her boyfriend. Okay? So, next we're going to look at some text from Kouri to her boyfriend. Kouri's going to be in blue. And it's like, good morning. I'm headed down there in a little bit, but I'm carpooling and got to get some stuff done and then I'll be there. And he's like, cool. Okay. So he knows she's coming. She knows she's going. She's nowhere around on Valentine's Day. And you'll see later and throughout this trial that she claims that they were home. They were both working from home. She even claims to have been there when this reaction happened. And here you've got text that shows no, she wasn't there. Now, there is a lot more evidence that was shown on day 6, but I can't include it here because then we would be nearly as long as the trial. But I encourage you, go watch because it was a lot. Now, we're going to move to day 7. And day 7, we only had one witness, and we talked about loans, her creditors, and the massive debt that she was in. On day 7, the state called Brooke Carrington, a forensic accountant who testified as an expert witness. She told the jury that she has approximately 38 years of education and professional training. She holds a bachelor's degree and an MBA and has testified in court hundreds of times since 1992. She explained that she was hired by the state in May of 2023 to conduct a financial investigation related to the case. Before that, she had been involved with matters related to Kouri Richins' estate. She testified that she had initially been hired to assist with the estate, but her work on that matter stopped in April of 2022 after a civil lawsuit was filed. She testified that the estate paid her approximately $14,000 for her services. As a part of her investigation, she told the jury that she reviewed thousands of documents connected to 27 different financial accounts, such as credit card statements, property records, email communications, insurance policies and payouts, estate documentation, and real estate records. She also spoke with a number of individuals connected to those financial records, including CPAs, realtors, insurance representatives, lenders, bank representatives, and both the previous and current owners associated with the Midway Mansion property. She explained that forensic accounting typically begins with a careful review of bank accounts to determine what financial activity appears normal and what might stand out as unusual. Among the accounts that she examined were several associated with Kouri Richins' business and personal finances, including the America First Credit Union account connected to Kay Richins Realty, a personal account opened around the time of the marriage, a line of credit through the Navy Federal Credit Union, and an America First account listed as a family account. Her testimony laid the groundwork for the prosecution's effort to show the jury how the Richins family finances were structured and how financial pressures or incentives could potentially factor into the broader narrative of this case. Okay, I'm going to pop the evidence or some of the evidence that was shown during her testimony, but I will have a hard time explaining this the way she did. So, my encouragement is for you to go watch her testimony so you have a full understanding of it. But I'm going to pop some of those things up so we can all look at it. Okay, we're going to move on to day 7. Now remember, you can pause those, screenshot, whatever you need to do to be able to read them. Okay, that was day 7, I thought. Yes, that was day 7. So we are going to move to day 8. And on day 8, we're going to cover beneficiaries, the estate trust, and the ex-boyfriend. Are y'all ready for this one? The state called LaShonda Rogers, a New York life insurance agent. Miss Rogers is a supervisor for Mr. Freckleton, and on June 2nd of 2022, she received a call from Mr. Freckleton regarding questions he had about a beneficiary change on a policy. He wanted to know what had occurred and what was going on. Seeing as only owners can change policies online or over the phone or with a document or a form that is submitted, he reached out to find out what happened. Ms. Rogers then reached out to the IT department to get the IP address that was used to make the change. On January 1st, 2022, the changes were made all within a few minutes of each other, and they were all from Eric Richins' login and the same IP address. Kouri's email was being used for the login, so it would appear to Miss Rogers that she had been managing the accounts online. On cross, she was asked about client IDs and which one was Eric's and which one was Cody's, and she stated that Eric started with a 9. Then she testified that the client ID was not used to log in, but it had been confirmed that Eric Richins' login had made the change, and the email associated with that login was KouriDarden@hotmail.com. Next, the state called Brian Freckleton from Freckleton Financial. And I realize I have typos on my slides. Brian was asked if he knew who Eric was and if he knew who Cody was, and he responded that he does. He testified that in 2007, after the marriage to his first wife, Eric had called him looking for life insurance. He was then asked if he became aware of Kouri Richins, and he responded that yes. He was also asked if he was familiar with C&E masonry, and yes, he was. He had drafted a buy-sell agreement for Eric and Cody's partnership with C&E Masonry. A buy-sell agreement is partners who put together an agreement as protection just in case one of the other partners becomes too ill or in the event of their death, so that the remaining partner can buy out their share of the business. Their agreement was funded through life insurance policies. The company at that time was worth $4 million. So they split the insurance policies into $2 million for each one. They had 4 total policies. 2 were for Eric and 2 were for Cody. In the event of a death, the owner would be the beneficiary so that that person would receive $2 million, and then he was obligated to buy the stock from the business trust. He was then asked about the insurance policies. And in the portal system, it has an alert that allows each of the agents to see what has been done, any changes that are made. And on January 1st of 2022, he received an alert that the beneficiary for the policy had been changed. He called both Cody and Eric and explained what happened, and he also reached out to New York Life Insurance to find out more information regarding the change. On cross, he was asked when they started the buy-sell agreement, and he responded in 2020. He was also asked if he assisted them in creating the login processes, and he testified that they're not allowed to do that. It's on the owner of the accounts to do that. But the email that was associated with Eric Richins' account as of June 2020 was KouriDarden@hotmail.com. He was also asked about the client IDs, and he didn't know about them. I mean, he knew that they had them, but he wasn't familiar with their specific IDs. On redirect, he was asked that if an email that was shown to him was the one that he received, and he identified it. And then he was asked when the policies were established, and responded that they were established in 2020. Okay, so real quick side note. It is storming here while I'm recording this, so the frogs and the cricket outside my window are going nuts and the thunder is loud. So if you hear that, I apologize. Also, please forgive my typos on the slides because I do this late at night after I've watched the trial day and after my house has settled down and all of my duties are done. So some of it is done very, very quickly. Okay, and although this may not be like the most important happenings of the trial, I thought it was funny and I wanted to share. So, about an hour into the day after the second witness, State Attorney Brad Bloodworth asked for a quick break. The jury's released, and then the judge addresses him, and he's like, "Forgive me, but I couldn't tell if you actually wanted a break or if you wanted to put something on the record." By this time, Mr. Bloodworth has already left his chair and has walked down to the end of the table, and he's off camera, but you can hear him say, "Your Honor, I need to go to the bathroom." I just thought that was funny. And after watching all these trials and all the drama and just the heartbreaking things that happen, sometimes it's nice to have a little humor in the middle of the day or at the beginning. When they came back from the break, outside the presence of the jury, Wendy Lewis for the defense says, "Your Honor, this morning we received a text from the state. We did not see it until we were sitting here in court." And I think I caught that moment, so I put it at the bottom. "They have provided documentation that Carmen Lauber did violate drug court after she was cooperating with this case." That's Giglio information, but she said Giglio. I did not have that information to cross her with. They further disclosed the text messages between her and Detective Maynard. They just talked about them. They didn't disclose them. But she said, "What's in these texts should have been available for me to use on cross." It's different than what she testified to. And again, she says this is Giglio information that was not given to us, and we move for a mistrial. So the judge asked, "So you're calling it Giglio information because you believe it's important to impeach one of the state's witnesses?" "Yes." The judge says, "Do you have any basis to say that the state had it before she was on the stand?" Wendy Lewis, "It was information we requested," and she's trying to say that. And he's like, "No, answer my question." So she says, "Yes, it belonged to Detective Maynard. He had this information and sent the email to Mr. Bloodworth prior to the trial starting." So the judge goes to the state. Attorney Brad Bloodworth, "I'm not entirely sure what the defense received this morning, but it was not for me. I've not heard about it until just now. I understand about 10 days ago, the defense submitted a request to the sheriff's office asking for information related to Miss Lauber and her supervision. That supervision, any supervision is what they asked for, but her supervision was done by Eric Maynard. I think they're referencing a violation involving where she was caught with an alcoholic beverage. I provided that information to the defense maybe 3 weeks ago in an email." Okay, so then the judge says, "Miss Lewis, I'm not going to shoot from the hip on this. You'll have to put this in a written motion with the timestamps and let the state respond." "Yes, I will, but for the record, about the alcohol violation was sent to Mr. Bloodworth on November 15th of 2023. Judge, what about Mr. Bloodworth's email to the defense he just referenced? Wendy Lewis, I saw no such email. The judge, okay, well, we'll get into that, but you have to put this in writing. We are not going to do this on oral representation in the moment. Is there anything else on that? And she says, "Not on that." Okay, so then Kathy Nestor gets up and she says, "We have another issue. We are aware that by tradition, the state sits next to the jury. We actually prefer that." She's smiling a lot during this. "But we are getting reports from people who are watching this on TV that the state is making faces at the jury during our cross examinations." And the judge interrupts and he says, "With respect, I have a better view of this than any of the cameras, and I haven't seen anything like that. So she responds, we've asked for the timestamps and we'll provide it to the court. All we're asking for is just a general admonishment that this is not appropriate and that they refrain from doing that. So Kathy Nesser says the second concern is that when Mr. Bloodworth is tendering the witness to the defense, he's making a statement. He says that he believes the defense will have questions for you. We believe that it is burden shifting and ask that he not do that. We don't believe it's intentional, but we are not required to ask questions, and we would ask that he not do that anymore. So then the judge responds, as a matter of law, I don't view that as a comment made to burden shift. If you stand up and say you have no questions, then you have no questions. I'm not going to admonish anyone for something that isn't happening. The only faces I've seen is counsel at me. I think we are well within the proper bounds of appropriate conduct from what I can see. Is there anything else? And she responds, we'll submit it in a motion, Your Honor. Okay, so that completes that because then they bring in the jury and they start the next witness. But before we start the next witness, I thought it would be fun to look at all the faces Kouri Richins is making at not only the witnesses, but the jury and the judge, since they called out the state for faces that I really haven't noticed, but maybe I miss them if they're happening, but I haven't noticed any of that, or I would have said something by now. But I have noticed her faces, so I thought it would be fun to take a look at the many faces of Kouri Richins. Okay, that's enough pictures of Kouri. The next witness that the state called was Ann Coates, a CMFG life insurance agent, also known as True Sage. She is a senior manager in claims. She testified about the life insurance policies connected to Eric Richins and the claim process following his death. She stated that a 2017 policy application was received in Eric Richins' name on May 12th of 2017. A later application for a 2022 policy was mailed in and received on February 4th of 2022 with a PO box addressed already pre-filled from the credit union. She explained that the company checks script check scores before approving applications and again at the time of the claim, and that once a year they run a match against death records using LexisNexis. In this case, the match indicated that Eric Richins had died in April of 2022. Coates testified that the applications are generally taken at face value and the process begins without calling the applicant. She stated that before a claim was paid, the company requested and received medical records, which showed marijuana use approximately 1 to 2 times per year, but no prescriptions. She testified that a $250,000 term life policy was paid by check in the amount of $251,558.82 and sent on January 17, 2022. A separate accidental death and dismemberment policy valued at $300,000 was still under review at the time. Coates explained that the records are kept for every call or transaction, and claim notes reflected that Kouri Richins called on April 28, 2022, May 4th, 2022, and June 7th of 2022, with additional calls recorded on June 15th and June 21st. She also testified that the policy welcome letter was mailed to the P.O. box in Camas rather than the Willow Court address. Eric Richins had other policies, including one issued June 9th of 2017, and that payments reference account ending in 2204. She further stated that applicants may be mailed broadly and can fill out an application and return it. The state then called Christina Miller, a divorce attorney. She testified about meeting Eric Richins in October of 2020. She explained that her firm follows a strict intake process where potential clients first meet with the paralegal, and then if vetted, a meeting is scheduled with her. Miller stated that Eric Richins was referred by Clint Benson and met with her on October 23rd of 2020 for approximately 2.5 hours. During the meeting, Eric completed paperwork and left without the information packet. He didn't take anything with him. And Miller testified that she provided legal advice. They discussed custody arrangements, scheduling for the weekends, and she noted that there were no other extended discussions about custody. At the conclusion of the meeting, she gave Eric a to-do list, but she believed that the divorce would move forward. He indicated wanting communication through Clint Benson and not through his email, while he planned to return to an estate attorney to revoke a power of attorney and a complete estate planning. On cross-examination, Miller testified that Clint initially reached out regarding the matter, although Eric later contacted her paralegal directly. She stated that the meeting with Eric was conducted with him and her alone. And during their discussion, Eric mentioned owning a business, and Miller says she received documentation showing the existence of C&E stone masonry, but did not receive documentation regarding any other businesses. She also testified that she reviewed forms related to child custody and completed an estimated child support worksheet with Eric. Miller stated that she would not normally refer someone to an estate planner, but noted that people often consider estate planning when thinking about protecting assets or planning for their future. The next witness the state called was Crystal Bowman Carter, an estate planning attorney. She testified that she worked with Eric Richins on an estate planning matters and had previously helped with a buy-sell agreement for C&E stone masonry. She explained that such agreements are common and outline what happens if one partner dies, often requiring life insurance policies to fund the purchase of the deceased partner's interest from the estate. She said that Eric had returned on October 13th of 2020 to update his estate plan and revoke a prior power of attorney he had believed had been abused. Intake worksheets were completed, and she reviewed a prenuptial agreement stating that C&E would remain Eric's separate asset except upon his death. She prepared estate planning documents, including a trust, living will, and health care directive, which Eric signed, with an effective date of November 3rd, 2020. She testified the trust provided 1/3 to Kouri Richins with the remainder to Eric's son, and that Katie Richins Benson was named the durable power of attorney to manage the property. A draft revocation of power of attorney existed but was never signed, though she stated the prior power of attorney had been revoked. Bowman Carter said that she had been instructed to communicate with Eric's sister and learned of Eric's death when Clint Benson called her. She later spoke with Kouri Richins and explained that the house was held in a trust, which she said made Kouri very upset, and that Kouri told her that the house was hers. She testified that she provided Eric with copies of his estate plan and will so he understood his wishes. Probate was opened on March 14, 2022, and she drafted the probate pleadings to have the nominated person in charge carry out Eric's wishes. On cross-examination, she testified that she had no personal knowledge of Kouri's business activities and did not investigate whether Kouri had contributed to the mortgage or purchased personal property. She said Eric had listed assets on an intake worksheet and estimated his net worth at about $4.6 million. She stated it is customary for the trustee to determine what qualifies as personal property, and Eric had listed household furnishings and effects. She also testified that a statement of intent was included because the client requested it. She said Eric preferred not to communicate directly by email and told her that Kouri had access to his email. She acknowledged that after speaking with Kouri, she did accidentally send an email intended for Katie that instead went to Kouri, in which she stated that Kouri did not hold the title to the house but had been provided for in the trust. She later represented Katie for a short time. My slide says Kouri, but it's actually Katie for a short time after Eric's death. She waived her fees for Katie and then withdrew in June, stating that Katie, not Kouri, needed a firm larger than hers. I apologize, guys. I did this stuff in the middle of the night. The last witness of the day was Robert Joshua Grossman, Kouri's ex-boyfriend. He identified as Kouri Richins' former boyfriend, and he testified that he met Kouri years earlier and later moved to Utah in 2020 to work with her. He said there was no formal contract for the work, but that she helped support him financially. He testified that he stayed in a flip property owned by Kouri and lived there with his dog without paying rent. He said she would give him money when he needed and had purchased him a truck, later giving it to her mother and replacing it with another one. He described their relationship as romantic shortly before he moved to Utah and said they communicated frequently, often exchanging text messages daily unless they were arguing. He also testified that the two had an on and off relationship and that he believed that they loved each other. He said Kouri had planned a vacation for April of 2022 as a birthday trip for him and that the trip had been booked in December. Text messages between them were referenced from late 2021 and early 2022, including discussions about their relationship and future plans. He also testified that on February 23rd, they had a conversation at a property in Midway about a property in Midway where they discussed a possible future together, though he later described the conversation as more of a fantasy rather than a realistic plan. He also recalled that Kouri was excited about closing on the property in Midway around March 2nd of 2022 and that they had planned to meet for a brunch that Friday. Grossman said he learned of Eric Richins' death on March 4th, 2022. And then approximately 10 days to 2 weeks later, he met with Kouri for the first time and they drove into the mountains to talk. During that conversation, he testified that she asked him about his military experience and whether he had ever killed someone while serving in Iraq and how that made him feel. He said that the conversation was serious and emotional and that he had never seen her act that way before. He testified that their romantic relationship continued for about 8 to 10 months before it eventually ended later in 2022. On Cross, he acknowledged that he and Kouri had known each other for about a year before becoming romantically involved, and that their relationship had periods where they didn't speak for extended periods of time. He confirmed that the planned birthday vacation for April of 2022 never occurred and that their relationship involved frequent texting. He also testified that he had used illegal drugs in the past and said he recalled seeing a cabinet. I'm sorry, guys, my slides are wrong. He didn't recall seeing a cabinet full of prescriptions. It was in a text message that Kouri sent him, but she said she's not that kind of person. He also testified that Kouri did appear protective over Eric's reputation during their relationship and did not seem happy about his death. He stated that their relationship ultimately ended later in 2022 and that it was the first time he had seen her in that time while he was there testifying in court. Note on the slides. I handwrite all of my notes, but then I scan them and let an app turn them into summary paragraphs. I'm no longer doing that because they're getting so many things wrong. So I apologize. Don't worry, we're not done with this witness yet. I'm going to pop some text messages up for y'all to view. I'm not going to read them. I'm just going to pop them up quickly. and then we'll move on to the last day of trial for week 2. Alright, guys, we're on the last day of the second week, if you're still with me. Today, we're talking for day 9, it's friends, lies, and a sandwich. The first witness on day 9 was Marie Bramwell, a domestic relations attorney with Gordon Law Group. She testified that she met with Kouri Richins for an initial in-person consultation on May 3rd of 2021. She explained that after the initial consultation, clients who choose to move forward are typically required to pay a $5,000 retainer fee. Following their initial meeting, she testified that she and Richins communicated primarily through email between May 2021 and January of 2022. She emailed Richins approximately 5 times, while Richins responded to her approximately 4 times during that same period. She stated that she did not believe they met in person again after the initial meeting, and a check admitted into evidence showed that Richins' retainer was ultimately returned. Outside the presence of the jury, there was a little bit of courtroom drama, but I'm not going to focus on that today. It is included in my information slides if you want to go back to that video and read the play-by-play. The next witness for the state was Becky Lloyd, a friend of Kouri's and an employee of C&E Masonry as their estimator. She testified that she had originally been hired on as an admin and had known Eric Richins since 2017, meeting Kouri around the same time. She described knowing Kouri as a neighbor, the mother of her kids' friends, and also her friend. She testified about a conversation with Kouri on December 17th of 2021 while the two were wrapping Secret Santa gifts for the C&E company and the families in their neighborhood. During that conversation, Kouri discussed issues in her marriage and a disagreement with Eric after a fight earlier that day. She said that Kouri had talked about a scheduling conflict between a work opportunity important for her career and a family sleigh ride that Eric had planned. According to Lloyd, Kouri said she felt trapped in the marriage and worried about losing her children, believing Eric could take them from her and that his family might turn the community against her. Lloyd also testified that Kouri said, in many ways, it would be better if Eric was dead. Lloyd also confirmed that Kouri helped her get the job at C&E by letting her know that the position was available, and she served as a reference to Eric. She testified that Kouri was on the company payroll while Eric was alive, but was taken off the payroll fairly quickly after his death by her request. Lloyd said that she later gave an interview about the conversation to a private investigator working for the Richins family and recalled meeting with him at her home on April 6 of 2022. During cross-examination, the defense played a recording in which Lloyd said she was not confident that Kouri had said Eric would be better off dead. But Lloyd testified she clearly remembered the statement because it stuck out to her because she was struck that Kouri had said it out loud. The next witness to be called was Gabriel Morin, the Mirror Lake Diner owner. He testified about a receipt for an order placed on February 14th of 2022. He explained that orders are checked out at the end of the shift, and the receipt reflected two items: a Greek omelet with feta, spinach, olives, egg, and added quinoa, and a bagel sandwich with 2 eggs, 2 pieces of bacon, pepper jack cheese, avocado, and tomato on a plain bagel, served with hash browns and packaged in a styrofoam box. Joshua Kays, a friend of Eric's, was then called to the stand. He testified that he met Eric Richins in 2014 through mutual friends and became closer with him after moving to Park City in 2016, where Eric worked as a subcontractor for a builder Kays was working with. Over time, they became friends, played on recreational sports teams, shared interests in camping and hunting, and often took camping trips or hunting trips together, sometimes staying in trailers, other time packing in and roughing it out. Kay said that they typically spoke about every other week, and he got to know Eric well during these hunting trips. He described Eric as very outgoing, confident, fun, magnetic, competitive, extremely dependable, and responsible. Case testified that he had never seen Eric sick or injured and had never seen him use over the counter drugs, prescription drugs, or illicit drugs, nor had he observed any indication that Eric used drugs at all. Case also testified about a phone call with Eric at approximately 2:11 p.m. on February 14th. He said the call stood out because of the tone and the emotion, explaining it was unlike any conversation he had previously had with Eric because they joshed each other and roasted each other constantly. He described Eric as somber, very serious, and sincere, which he said was unusual because Eric was typically upbeat. During the call, Kays asked Eric questions, offered suggestions, and asked if he was okay, and asked whether or not he was going to the hospital and what he planned to do about the situation. Kays testified that he later spoke with his wife about the call that same night, told a couple of mutual friends a day or two later, and after Eric's death, discussed the conversation with Cody. On examination, the defense had no questions. The next witness was Chelsea Barney, Kouri's friend. She testified that she and Kouri Richins had been friends since junior high school and spoke frequently, seeing each other as often as they could. Barney said she considered Kouri her best friend. During a trip with friends to Sun Valley in October 2020, Barney learned about a home equity line of credit Kouri had taken out on the house. She testified that Kouri told her Eric had become angry and turned off her credit cards after discovering the loan. According to Barney, Kouri said she used the money to buy a house to flip and sell and asked friends on the trip to cover expenses, saying she would reimburse them when she could. Barney testified that in February of 2022, she was at a friend's brunch with Kouri when Kouri received a call from her doctor. Barney said that Kouri told those present that the doctor believed she might have cervical cancer and that she would need to go in for a biopsy. She testified that she was present when Kouri called Eric and told him what the doctor had said, and according to Barney, Eric expressed concern but remained calm and said that they should wait until they knew for sure. She testified that she did not know Eric to use illicit drugs and said she had never seen him use pain pills. She said the only substance she was aware of Kouri or Eric using was THC gummies. Barney also testified that on March 4th, 2022, Kouri's mother called her and let her know that Eric Richins had passed, and she went to Kouri's house immediately. She said that Kouri told her she had gone to sleep with one of the boys, and when she returned to the bedroom, Eric was cold and not breathing. Barney also testified that Kouri said that they had been celebrating a job she had and had a drink that night. She testified about an argument between Kouri and Amy regarding the house that Amy said belonged to Katie. Barney said Kouri became upset, crying, hysterical, and collapsed after learning the house was not hers. She testified that she had believed Kouri was successful flipping houses and had no idea she was in financial distress. She also testified that she purchased a home from Kouri because she needed a place to live. She paid $45,000 down payment, which she described as her life savings, wiring the money in two transfers to Kouri intended to go towards the mortgage. She testified that the loan was in Kouri's name, but she paid the mortgage payments of $2,900 per month. Barney said she believed she owned the house through a warranty deed, but later learned that the deed had never been recorded with the county. She then testified that after Kouri was arrested, she learned a loan had been taken out on the home. Barney said she contacted the mortgage company and was told that the deed had never been filed. She testified that she continued to pay the mortgage, but in September of 2024, she was evicted when the house was transferred to new owners by Kouri. The state had no more questions for her and tendered the witness to the defense, and they took a break. When they came back from the break with no jury present, prosecutor Brad Bloodworth cited the case of Takesy B. Backsy and said he had accidentally omitted an email, which was actually a text message he meant to introduce, and asked the court if he could add it and then tender the witness. The court said yes. They asked Miss Lewis if she had any objection, and she responded that she didn't know anything about the case he was citing, and the judge replied that it was a joke. The witness and the court reviewed the text message at the same time, and then the jury and the witness proceedings went on. Barney also testified that about the phone calls the court heard recorded on June 17th between her and Kouri that were offered for statements made by the defendant. Additional recordings included a phone call from March 19th between Kouri, Bryce, and Chelsea. Barney testified that one call was made to see how Bryce felt about everything that was happening. I haven't included any of that here because, like I said, I didn't want this to be as long as a trial day. So I encourage you to go back and watch this witness, okay? Because there was a lot of stuff that came through. The last witness of the day was Allie Staking, Kouri's friend. She testified that she and Kouri grew up together and had been friends since junior high school. She said that they talked frequently and that she had been one of Kouri's best friends. She also testified that the two had attended a retreat where they wrote their life stories in third person. That was eventually admitted. The defense raised questions and they wanted to put the whole thing in, and eventually it was. She testified that she was familiar with Kouri's house flipping business and believed it was successful. She says she did not know that Kouri was in any financial distress. She also testified that she knew Josh Grossman, not Gressman, my slides again, because Kouri had told her about him. And Kouri had said that her and Josh had been having an affair during 2020. Staking also said that Kouri later told her that the relationship had been broken off around the weekend of February 20, 2022, and that it had been over for about 9 months. I'm so sorry, guys. I will redo these slides and repost correct information. Staking testified that on February 20th, 2022, they discussed the Valentine's Day. She said that she could not remember who started the conversation, but there was a group of them there, and Eric had said that he thought Kouri had tried to poison him. She testified that Eric had said it jokingly. Kouri laughed and responded with, "That's not what happened," saying he had had an allergic reaction and it was not that dramatic. During cross-examination, she testified about a trip to Hawaii with the families in early 2018. She said Kouri had discovered that Eric had placed THC gummies in her suitcase. She said Kouri was not happy, but Eric thought it was funny. She also testified that she had been told the gummies were bad gummies on a night that she had came to visit Eric and them before his death, and Eric had said that they had made Kouri sick and he didn't want her to take them. She testified that she had taken gummies with them in the past and that for a period of time they were getting them from one person. This cross was really confusing, so I'm not really sure what they were getting at here. She later learned information from a friend named Kelsey that Eric had died, became upset, cried, booked a flight, and came the next day. She described Kouri as distraught. She testified that there was a gathering at the house either the night that Eric died or the next night, and she said that many friends and family were there. And it was not a planned party, but people had came to share their condolences. They were drinking and talking about Eric. She testified that it was not intended to be an upbeat or celebratory event. She testified about taking a photo of the night and the gathering showing Kouri, Bryce, Allie, Chelsea, and Amy. She said that she stayed overnight at the house and she was there when Kouri attempted to access the safe to find the will and then called a locksmith, and Amy told Kouri that the house wasn't hers. She testified that Amy and Bryce had been leaving and saw a logo on the locksmith truck and came back inside. She said that Kouri was frustrated and angry, and she believed that Kouri's concerns were valid. On Read It Right, she testified about the Hawaii trip again, saying the conversation about the gummies had been a joking conversation. And she also testified that the gathering on March 5th, where friends and family were drinking and toasting Eric, she said this was the photo that they showed her was before Bryce removed his pants, because obviously he was still dressed. The court admitted it a video of the gathering, but it wasn't shown because it had to be redacted to blur the children's faces. She was asked if anything unusual happened the night of the gathering or the wake involving Amy, Bryce, or Chelsea, and she said no. Alrighty, guys, that does it for week 2 of the Kouri Richins trial. I will no longer use my app to summarize my notes. I apologize. At this point, they're just there for the witness pictures. I'm very upset about that, but I will correct it. I do apologize, and moving forward, you can take the information to the bank. I'm glad you're here with me checking this out. I'm glad you found yourself to True Crime Stories, the trial recap section, and we're going to continue to cover this trial, and I will see y'all next time.